Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
Your Honor, if I may, a couple of things.
Yeah.
First of all, the state has received a supplemental report and is prepared to establish probable cause at this
Okay.
time. And then also, if the defendant is electing to go pro se, the state would request a pro se colloquy.
Okay, I think that may have already happened. But in any case, so Mr. Blatt, right now, this is on for a pre-trial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one, but which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it Meyer?
Yes.
And the prosecutor's name again is
Last name is Kidmacher.
okay. And first name?
It's Gabby.
Okay. And can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And, the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And
Right.
the bond is equal to the insurance that a driver would need to have.
This is one of those court hearings that starts off routine, and then immediately goes off the rails. Today's case is a follow-up involving Leonard Blatt, a repeat sovereign citizen who's already made a name for himself by trying to argue his way out of reality. This is supposed to be a simple pre-trial conference. No witnesses. No jury. Just logistics. But Leonard shows up armed with the same recycled legal myths, internet law school talking points, and a deep confidence that he knows the law better than everyone else in the room, and that's what makes this so fascinating. Because while Leonard thinks he's putting the court on trial, the judge is quietly letting him talk himself deeper into trouble. You're going to hear flag arguments, oath of office demands, Black's Law Dictionary references, and the classic sovereign citizen belief that words mean whatever they want them to mean. But you're also going to hear
Have it on the, I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't, we're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, things that don't really matter with regard to your case. You might not believe that it doesn't matter, but it really doesn't. Right now, you're the one charged with driving with license suspended in the 3rd degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now,
Yeah.
at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
Yeah, I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
But the city of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this case, right?
I don't know about the franchise aspect of it, but it is a municipal case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity?
This single sentence tells the judge everything he needs to know. When someone facing criminal charges casually says they're not sure, they need an attorney, that's not confidence, that's misinformation. This is one of the most common warning signs judges see with sovereign citizens and pro-Southeast defendants who've gone down the internet rabbit hole. Leonard believes the courtroom is a debate stage, not a legal process. He thinks clever phrasing and gotcha questions can override statutes and case law. What's important here is what the judge doesn't do. He doesn't lecture. He doesn't mock. He simply acknowledges the situation and keeps moving forward. That's intentional. Courts are required to give defendants every reasonable opportunity to understand what's happening. Leonard is being given
one of the ways they can do that, and they're not alone in this, a lot of cities do this, not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the 3rd degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies, that obviously would be under the revised code of Washington, and that would go to Superior Court. That this is limited jurisdiction, and we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple, and that's why you're here. That's how you're here.
Are you going to be the judge throughout all the hearings in this process?
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not. Again, don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset
Yes.
about being called a criminal. I'm not a criminal, and I want to clear my name. Believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the 3rd degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine. As a practical matter, that would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. A passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that
Here it is, the greatest hits album of sovereign citizen arguments. Leonard demands to see oaths of office and bonding documents, comparing judges to drivers needing licenses and insurance. This analogy sounds clever on the surface, but it completely collapses under even minimal legal scrutiny. Judges don't derive authority from carrying paperwork, they derive it from statute, election, and appointment. Oaths are filed once and remain valid unless legally challenged through proper channels, not Zoom hearings that each judge responds perfectly. Calm. Direct. No theatrics. He explains that the oath exists, it's on file, and Leonard is welcome to review it through appropriate means. That's due process in action. But notice what Leonard is doing.
And you get caught behind the wheel driving, and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the Revised Code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all those things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving and were you validly licensed, or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, now I know that anything I say can be used against me in court. I'm fully aware of that.
So hang on just a second. Well, it can, but you shouldn't admit that. If by traveling you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial. My defense is going to be something completely different. Now, I noticed something on the website for the court. It says jury instructions or jury guide.
Okay, so hang on just a minute. Before we get...
This moment is subtle but critical. The judge draws a clear boundary. We are not here to debate imaginary legal loopholes. We are here to decide how this case moves forward. Trial or resolution. That's it. Leonard, however, refuses to engage with that reality. Instead, he frames the situation as though the court is obligated to indulge every argument simply because jail time is theoretically possible, but that's not how due process works. Due process guarantees fairness, not endless delay or unqualified legal theories. The judge is being more than reasonable here, repeatedly asking Leonard where he sees the case going. This is the legal equivalent of someone refusing to answer a yes or no question because they don't like the options.
Your options are either come to some sort of resolution with the city, or you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions, and that means if you wish to go to trial, you can do that. And we can have a different conversation about your ability to represent yourself, which you certainly have a right to do, but I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you, but when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set, but we're gonna have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well, the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors, will be impaneled from the jury rolls within the county. And it'll be up to them.
There'll be 6 jurors and an alternate juror, right? So that's 7,
Yeah,
right?
typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judges to deal with legal issues, not the
That's
jury.
true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because I've already stated
Jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. And that's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. That's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree, and the jury's going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some, the right to travel is being impinged by the requirements of a license. It's not.
Leonard thinks he's just uncovered a fatal flaw in the prosecution. State versus city. Franchise arguments. Jurisdiction confusion. But what he's actually demonstrating is a complete misunderstanding of how municipal courts function. The judge explains this patiently, breaking down how cities adopt state statutes and how limited jurisdiction works, and this is important for viewers. Nothing Leonard says here invalidates the charge.